Supplementary.
Lordship, I beg to mention item number 1 on behalf of the counsel for the respondent, Mr. Aforesaid. The said counsel is currently out of station due to some
Have you
medical
informed the appellant's counsel?
Yes, the opposite party has been informed.
I am for the appellant. We
Ah.
received the
What is your name?
My name is V.K. Chishi, sir, Your Honor.
Mr. V.K. Chishi, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent, Mr. F. Faridi. Also, Mr. B. Barua, learned counsel for the appellant, who does not raise any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed on Ramesh Shetade.
Your Honor, if it may please this honorable court, mid of May be considered.
4th May,
Mid.
15 May. 15 May.
Much obliged, Your Lordship.
My lord, there is an interim order. in
Interim
the
order
I-
shall
connected.
continue till next day. Ramesh Epale, home.
My lord, the earlier interim will go.
The interim order shall continue till next day.
My lord, publish.
Supplementary, module item 42.
My lord, pleases. My lord, this matter can be taken up when the orders matters have been taken, my lord. It has been wrongly categorized as withdrawal item, my lord.
It is not withdrawn.
It's not.
He has
written,
filed the mentioned memo as withdrawn.
My lord, I was
It
being
is
told by,
written withdrawn.
I was being told by the court master, my lord, to mention it as a withdrawal. So I have done that.
No,
my lord.
you will not be guided by court
My
master.
lord, I understand, my lord. I apologize, my lord, and that is the reason, my lord, I'm saying, let it be.
It is the council who should. Okay, we'll take it up in the orders column.
Orders, my lord. Deep problem.
Bill, hearing return item 5. Well, Lordship, CD was called for, CD has not been received.
None has appeared for the petitioner on call. Mr. B. Sharma, learned additional public prosecutor, prays for some more time for production of the case diary. The prayer is allowed. Let this matter be listed. When can you produce?
Lordship, immediately after the vacation, 22nd.
Let this matter be listed on 23rd
23rd.
23rd of April.
Item 6.
Pleasure, Lordship. The regular bail application, Lordship. The trial has already commenced, Lordship. And the court cases already released on bail by His Honorable Court, Lordship. The accusation is technically similar to those who has already been bail on bail, Lordship. I have annexed that bail order, Lordship. But you'll find that bail order at page 66, Lord. It starts from 66, Lordship. Relevant person at 68. It starts from paragraph 5.
What is 66?
This is the bail application, Lordship, bail order, Lordship,
Of
other co-accused who are on bail, Lordship. Accusation, I think, is
66 is a bail application filed by
co-accused, Lordship,
4 accused who were granted bail.
by this court, Lordship, by your Lordship,
Who?
By your
All the 4 were granted bail.
by your Lordship.
All of them were granted bail or not?
Yes. All the petitioners were released on bail, Lordship. The case is pending at the stage of evidence, Lordship.
Why your prayer was rejected by trial court?
Lordship, on the ground that there are sufficient increment materials, Lordship. The case diary as well as the search sheet, Lordship. That is the ground, Lordship.
Against these four also, charge sheet was laid.
Yes, yes.
Where is your rejection order?
Lordship, I will find it very at page 57, Lordship. Page 57, annexure 6, Lordship. Third paragraph.
And your prayer was rejected by this court also earlier.
No,
This is for the,
one of the petitioner Lordship approached before and during the pendency of the said bail application Lordship, search sheet was laid down so before the trial court Lordship. That is why they was directed to approach before the trial court. Actually, they approached before the trial court twice, Lordship. And
now
that was
what is the
rejected.
stage of trial?
At the stage of evidence Lordship.
PW1 or one examination has been done. PW1.
Yes, other co-accused are released only.
Yes, Lordship, there are two grounds, Lordship. First is, Lordship, that was in the during the stage of investigation. And secondly, Lordship, these are the petitioner before your Lordship, now Lordship, they are the main accused. As
No, no,
reflected in your
not the main.
Lordship's order also, Lordship 68, page number. They were absconding, Lordship, at the time of investigation.
That is true, absconding Lordship.
Subsequently, Lordship, charge sheet has been.
After receiving the summons Lordship, they voluntarily appeared before the court. Lordship. And the court by issuing the custody warrants, they sent.
Against how many accused persons charge sheet has been laid?
13.
13 Lordship,
13. How many are on bail?
8 Lordship.
8 are on bail. They are also facing trial.
Lordship.
Then why to keep them? These
Yes,
five?
Lordship will kindly take up the scan copy. And Lordship, as reflected by the trial court also, Lordship, the eyewitnesses who have specifically implicated the petitioners, these are these petitioners. Altogether, Lordship, 5 petitioners, Lordship, they are implicated by all the eyewitnesses. I have flag marked, Lordship, 3 eyewitness, independent eyewitness. They are arrayed as PW 6, 2, and 3. Then, Lordship, the other witnesses, 3 number, Lordship, out of whom PW1 has already been examined, they have also implicated the present petitioner. In their regard, Lordship, all the witnesses are consistent, Lordship, that they were present and they assaulted the victim.
Search sheet has
That
laid
is very clear, Lordship. I have flag marked the eyewitnesses also.
No, what is your ground of objection?
Lordship, as reflected by the order at page 57, Lordship, there are eyewitnesses who are yet to be examined, including the complainant herself, Lordship. So the
Who is the complainant?
complainant is
Who is the
Lordship,
wife Lordship?
wife, Lordship.
PW?
I have to check the Ajanta Kutum, Lordship.
It will be one Lordship.
PW, no, not PW1. PW1 has already been examined, Konok Pegu. She is the complainant Ajanta Kutum,
Ajanta
if I am not wrong, Lordship.
Kutum is the complainant Lordship.
Complainant, too?
Yes.
Yes, he is the complainant. And the eyewitnesses, Lordship, Bogi Kutum, Konok Pegu, Prabhat Pegu, they are the independent eyewitnesses.
PW 6.
6.
Where are their names in the charge
You
sheet?
will find it at the charge sheet.
Page number?
Charge sheet 29, Lordship. Page 43, Lordship, will kindly come.
Page 43, yes, Lordship.
Ajanta Kutum is arrayed as PW1, but she has not been examined as PW1. And Bogi Kutum is Lordship. Boga Kutum is PW6. Konok Pegu is arrayed as PW2. And Prabhat Pegu, PW3. 6, 2, 3, and 6. They are the independent eyewitnesses. Apart from them, Lordship, the complainant herself, Ajanta Pegu, and Rita Dole. And Lordship, Indreshwar Pegu. These are also witnesses, Lordship.
Who has been examined? Konok
Only,
Pegu.
Lordship, Konok
PW2.
Pegu. Konok Pegu. PW2. So these are the materials. If Lordship kindly peruses the evidence.
No, then what is the basis of your opposition? Why are you objecting? If he's released, what will happen?
Yes, Lordship, it will hamper the trial, Lordship, because
How?
these eyewitnesses, Lordship, they are from the same villages.
So you apprehend that they
Yes.
may be influenced.
Yes, they will influence, Lordship, because the complainant also has not been examined so far. And she.
Then let them be examined.
Lordship, kindly, the same accusation, Lordship. Lordship, kindly have a page 45, Lordship. Last paragraph, Lordship. Last paragraph, that is search it, Lordship. 45, Lordship.
Page number
45, Lordship.
45 or 35?
45.
Yes.
During investigation, the involvement of the accused persons, namely Junmoti Pego, Eliasa Junmai, Simoti Eliza Pego, Simoti Ranjita Pego, Simoti Onova Pego, Simoti Benita Pego, Bani Pego, Vishnu Kutum, Vikas Pego, Anil Pego, Vikas Pego, Anil. Petition number 5, Anil Pego, petition number 1, Hidden Kutum, Falguni Pego, Utpal Pego, and are found well established, and the ingredients under section so and so has been fulfilled, which is the primary PC well established against the arrested and absconding accused.
No, Mr. Sharma,
Yes,
how they stand differently from the accused who are already granted bail?
Lordship, because firstly, Lordship, some accused were granted bail during the investigation stage. And
Lordship,
now the
lack of
matter has been
potential.
charged sheeted, so the parameters shift, Lordship, because at the time of investigation, Lordship will look at different consideration and after.
No, but they are facing trial.
Yes.
They may also face trial.
Yes, Lordship, and that is.
Why
why,
why to keep them behind bar? There must be some logic for
Yes,
keeping them behind bar during.
yes, yes.
What is that logic?
Lordship, there has to be some submission on their behalf that the trial has not, there's delay or anything, Lordship. Nothing is there, Lordship. Trial is progressing at a fast pace. That is my first submission.
No.
Secondly, Lordship, during
Yeah,
investigation,
I want Perry.
on what basis you discriminate between 8 accused and other remaining 5 accused?
Lordship, when the case was filed, Lordship, they absconded. The other persons who were arrested, Lordship, they came before your Lordship, filed a bail application, and it was given to them, Lordship, considering the progress of investigation. They remain absconding, Lordship. They could
But
not be
later on they surrendered.
They surrendered only when there was no avenue left, Lordship.
Now the consideration is that will they face trial?
Yes.
Yes or no?
Face the trial,
Yes.
Lordship.
Is there any apprehension that they will influence the witnesses?
Yes,
Any
it is there,
condition,
Lordship.
Lordship.
They are from the same village. And it
But so are the other accused persons who are on bail.
You're also from the same. place.
My query is how these five accused persons
Lordship.
stand on a different footing than the accused who are already
Yes.
granted bail.
For that purpose, Lordship will kindly take up the scan copy. I have flag marked the statement of the eyewitnesses. They have specifically mentioned
Ramesh,
these.
scan copy dio.
Against other, Lordship, the eyewitnesses, their statements may vary, Lordship, or they may have omitted 1 or 2 accused persons. But regarding these 5 petitioners, Lordship, they are very consistent, Lordship, the eyewitnesses. Each one of them, Lordship.
Falguni Pegu is a male or female?
Male, Lordship. Any condition, Lordship.
Secondly, Lordship, this being a murder case, Lordship, the offense has to be seen by your Lordship. And there actually be only one PW has been done so far out of 9 PW. And only these 3 witnesses are of utmost importance, Lordship. That is the eyewitnesses, Lordship.
Okay. Heard Mr. B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely 1, 2, 3, 4, and 5, who are detained behind bars since
12/11.
the first 4 petitioners are detained behind bars since 12/11/2025, whereas the 5th petitioner, namely Vikas Peku, is behind the bars on 6/8/2025. In connection with Sessions case number within bracket T1 13/2025 pending before the court of Session Judge Dhemaji. The corresponding PS case is Jonai PS case number 37/2025. The charges against them are framed under which sections?
1032.
Only 103.
03 subsection 2.
103 within bracket 2 of BNS.
On 6/1/26.
The gist of accusation in this case is that court paragraph number 2 from page 68 and add a line. Later on, the husband of the first informant succumbed to his injuries. Stop. After completion of the investigation, the charge sheet was laid against the present petitioners and 8 other accused persons. Eight other accused persons.
Is 29 Lordship, that is a section.
Under section 61 within bracket 2/189 within bracket 2/103 within bracket 2 of BNS. Stop. Learned counsel for the petitioners have submitted that the petitioners were not arrested during the course of investigation, and they themselves, all of them surrendered.
1 to 4, they were surrendered, Lordship.
5th one,
5th one is arrested by the
the petitioner number 1, 2, 3, and 4 surrendered before the trial court on 12/1/2025, whereas the
12/11 Lordship.
12/11/2025, whereas the
5th was arrested.
5th petitioners, namely Vikas Pegu, was arrested on
6/8.
6/8/2025. He submits that though the charge sheet was laid against 13 numbers of accused persons, However, the remaining 8 accused persons were already granted bail. He submits that 4 of the accused persons he submits that some of the accused persons were granted bail by this court during the course of investigation on 12/6/2025 in bail application number 1705/2025. He submits that the petitioners also stand on same footing like that of those accused persons who are already on bail. Learned counsel for the petitioner further submits that the petitioners are ready to face trial and ready to cooperate in trial, and their custodial detention may not be necessary for fair completion of trial. They are ready to abide by any conditions put by this court while granting bail to them. On the other hand, learned additional public prosecutor vehemently opposed the grant of bail to the present petitioners. He submits that all the aforementioned petitioners did not cooperate during investigation and remained and evaded the course of justice during investigation. He further submits that the other accused persons who are on bail were granted bail during the course of investigation, considering the progress made in the investigation. He also submits that the present petitioners stands on a different footing from that of those petitioners who are already on bail. He also submits that there are at least 3 independent witnesses, namely Prabhat Pegu,
Boga Kutum,
Boga Kutum, and
Konok Pegu, who has already been examined. Also.
Konok
Two
Pegu,
eyewitnesses as per the search sheet, Lordship.
and Konok Pegu,
One has already examined, Lordship.
Konok Pegu has already been examined.
who has been already examined. He also submits that the complainant Srimati Ajanta Kutum is also not yet examined. He further submits that considering the incriminating materials against the present petitioners, they may not be allowed to go on bail before examination of the above mentioned 4 witnesses, as they hails from same locality, and there is every possibility that if they are released on bail, they may try to influence the independent witnesses. I have considered the submissions made by learned counsel for both sides.
I'm sorry, Lordship, for interrupting. I'm sorry, very sorry, Lordship. Here, Lordship will kindly take note, Lordship, that earlier they had filed 2 AB. One is, Lordship, AB 2576 of 2025. This was, Lordship, filed by the petitioner number 1, Anil Pegu, and Utpal Pegu, along with some other persons, Lordship. There, Lordship, it was rejected. Yes, it is an AB. Dear Lordship, will kindly, I want to just read the observation of your Lordship, if Lordship permits me. It appears that while considering the application for anticipatory bail, which was filed on earlier occasion, earlier also it was rejected. I will give that number, Lordship. By the petitioner, this court has gone through the case diary and found sufficient materials against the petitioners. The completion of investigation and laying of the charge sheet may not be the only ground on which an application for bail may have to be considered. The role played by the petitioners and nature of accusation made against them is also a factor to be considered while considering an application for AB, that too which was moved for the second time. In the instant case, the petitioners remained absconder during the period of investigation, and after finding sufficient material against them for their role in killing of the husband of the informant, this court is of the considered opinion that mere filing of the charge sheet may not be considered as a favorable condition on the basis of which bail may be granted to the present petitioner. And this order, Lordship, has not been mentioned or annexed in the.
Those are
written application.
anticipatory bail, Lordship. Now it is the regular bail.
But Lordship, they should place all the relevant facts before your Lordship, because. Lordship,
25, order dated?
Order dated 3/11/25. Because Lordship has put up a pointed question before him, Lordship, whether any AB was filed or whether it was rejected. He
Yes.
mentioned only one bail application.
No.
Which
This is regular bail application.
AB
Lordship.
AB number?
Lordship has not put
AB
that
number
question, Lordship.
2576/26. That was the second bail application. The first one was, Lordship, I'm sorry, the first one was AB 1419/25 of 2025. There also, Lordship, the petitioners were there, Lordship. Utpal Pegu was there, and Vikas Pegu was there, Anil Pegu was there, and all the petitioners were there, Lordship. There also, Lordship, the AB was not granted by your Lordship.
The line petitioner submission. No, learned counsel for the learned additional public prosecutor also submits that on earlier occasions, the petitioner also approached this court seeking anticipatory bail. However, same was rejected by this court after perusal of the case diary. Gorpera ki asile, last line. I have considered. Okay. On perusal of the records, it appears that in the charge sheet that there are incriminating materials against the present petitioners, and they have been specifically implicated by at least 2 witnesses who are shown as eyewitnesses in the charge sheet. Out of those 2 witnesses, one, that is namely Kanak Pegu, has already been examined as an eyewitness.
Lordship, out of three eyewitnesses.
But in the charge sheet, only 2 have been shown.
As per the certificate, Lordship. Why we annex it?
Stop. It also appears that the other eyewitness mentioned in the charge sheet is namely Shri Boga Kutum is yet to be examined. Considering the statement of the said witness, which was recorded under section 161 of, which was recorded under section 180 of BNS, as well as considering the submissions made by learned counsel, learned additional public prosecutor, this court is of considered opinion that in view of the incriminating evidence of the said eyewitness against the above named petitioners, it may not be proper to grant to release the petitioners on bail at this stage before examination of the said eyewitness, namely Boga Kutum. The prayer for bail is therefore rejected at this stage. The trial court is directed to make all endeavors to examine Shri Boga Kutum, within bracket the remaining eyewitness, as early as possible. After examination of the said eyewitness, the petitioners may approach the trial court for seeking bail in this case
Kindly
accordingly.
appreciate the deposition of the eyewitness at Konok Pegu. Lordship kindly observed that of the. What is the deposition of the Konok Pegu, Lordship?
Of,
Kindly
no, Konok Pegu has
it is
already
already
been
examined.
examined.
Kindly appreciate the deposition of the witness, Lordship. I
No,
think
that is not relevant now. We are rejecting your prayer because one of the eyewitnesses is remaining. Let him be examined, and after his examination, you may move the court again.
I think that will help to decide the.
This bail application is accordingly rejected at this stage with above observation.
Obliged, Lordship. May I please, Lordship.
You have filed your objection.
Fine. Lordship, if it's a problem, Lordship, I can hand over my office copy, Lordship.
No, let me see whether it is there. It is there.
Then it's all.
Yes, what is your submission?
Yeah, Lordship, I have earlier also have submitted that my ground is, nothing was recovered from me. I was in the official duty, the plea of alia is there, Lordship. And on the only implication under section 29, on the basis of CTR and bank transaction. That my grounds are the illegal detention, Lordship. I was apprehended on 2nd of September.
When?
2nd of September, 2/9/2025.
Yes.
At Gauhati Airport, Lordship. Then I was produced before the NCB office, and a statement was recorded on 2nd of September. But I was not produced before the magistrate on 3rd. I was produced before the magistrate 4th of September. On 3rd, they have said in one place that they have taken the statement, but this is not record, Lordship. No record is there. Because 2nd of September.
Where were you on 3rd?
In the NCB office, Lordship.
At night?
NCB office, Lordship. 2 to 4, I was continuously in the NCB office. No statement was taken on 3rd, but it is said one place. This is in page number 5051, Lordship. 50, Lordship. Kindly come to the page now. Please. Diagram 43, that on dated 2/9/2025, Mohammed Zahia Khan appeared before SN Prasad, Inspector NCB Gauhati, to tender his voluntary statement. However, in the meantime, Zahia Khan told that he will give his further statement tomorrow on 3rd, Lordship, due to his tiredness, Lordship. But on 3rd, no statement is recorded in the charge sheet, Lordship. This is The statement of 2nd of September is given in page number 175. 175, Lordship, kindly. 179, serial number 44. Voluntary statement of Jahia Khan dated 2/9/2025. Then, if statement is recorded on 3rd, that it will come after that on serial number 45 or 46. The serial number 45 is copy of arrest memo, Jahia Khan so and so. So this is not in the record. Yes. And thus I have been kept in the illegal custody.
Where
more
is
than-
that statement? Where is that statement that you were kept in illegal custody? In your bail application, where is that statement?
I hope. Lordship, this is paragraph number 9, page number 6, Lordship. Page number 6, paragraph. That the petitioner was apprehended at LGBI Airport, Gauhati on 2nd of September 2025. And appeared before NCB Gauhati where he allegedly tendered his voluntary statement. However, the prosecution illegally detained the petitioner till 3rd September at about 17 hours on the pretext of recording a voluntary statement. Strikingly, no statement dated 3/9/2025 finds mentioned in the offense report, except the statement dated 2/9/2025. It is further submitted that there is no record indicating at what time the petitioner was permitted to leave on 2nd of September 2/9/2025, nor is there any record reflecting the exact time of his appearance before the NCB authorities on 3rd, 3/9/2025. The absence of such crucial time entries clearly establishes that the petitioner was kept in illegal custody for more than 24 hours without being formally arrested and without facing produced before the nearest magistrate within the stipulated period prescribed under law. Sub-para is there, Lordship. Thereafter, the petitioner was shown arrested at 17 hours on 3/9/2025 and was subsequently produced before the learned special judge on so and so 4/9/2000. Since the date of his arrest, the petitioner has been languishing in judicial custody. The entire sequence of events demonstrate serious procedural irregularity and a clear violation of the petitioner constitutional and statutory safeguards, rendering his continued detention unjust and unsustainable in the law of law. This is my first grounds. The second grounds I have taken.
No, at what time you were apprehended on 2nd?
It's a 2 p.m. Lordship.
Where is that statement?
Particularly date, time is not I have mentioned. Just I arrived in Gauhati Airport. Then I was.
No, from where we will know at what time you were apprehended?
Yes, Lordship. This I have not stated.
No,
but
whether NCB has acknowledged anywhere that you were apprehended at on 2nd of September in any of their documents. Apart from your statement.
Lordship, this is page number 49, Lordship. The last paragraph, actually, this is page number 50, actually, this is at the top of the page.
Page number?
Page number 50. 50.
Yes.
Gauhati Zonal Unit to serve the notice under section 67 NCB 1985 to Jahia Khan and take necessary action as per law. Thereafter, SN Prasad, Inspector, NCB Gauhati, proceeded to Gauhati Airport and served notice under section 67 and NDPS Act 1985.
They are only saying that in airport you were served notice.
There I was apprehended and I was taken to the NCB office 30 and my statement was recorded and I was taken in the NCB office illegally.
No, whether you voluntarily appeared or you were apprehended from which material, we will come to that finding.
Lordship, my next flight was from Gauhati to Manipur, but I was not allowed to go. It is because I have not voluntarily appeared. I was taken to the NCB office, Lordship, because my flight was from Agartala to Manipur,
No, that is,
Imphal, via Gauhati.
their plea is that you voluntarily went to the NCB office to give your voluntary statement after receiving notice under section 67. That is the plea of NCB. That they are wrong.
Not voluntary, Lordship. I
From
volunteered.
what is the material on the basis of which we can decide that they are not saying truth? Because in their complaint, they have stated that in airport 67 notice was served on you. And then you appeared before NCB to.
This is their statement, but I was taken to the NCB office. Yes, and if I would have been allowed, that I could have gone to Manipur Imphal. Then later on I could have come. But on that day I was taken to the NCB office Gauhati, and on 3rd I was taken to the NCB office. No statement was recorded, Lordship. I was produced before the magistrate on 4th, Lordship.
And yes, Miss. Anything else?
Yes, next to two more grounds are there. Section 60 regarding CDR and bank transaction, Lordship. So I will support with the judgment of Allahabad High Court also.
65B, Allahabad, what Allahabad High Court says, at the bail stage of.
Yes, sir. The bail.
Yes.
On this ground, the bail has been granted. This is the last paragraph in the first page of the last paragraph. I have highlighted this. It is also submitted there so far as the certificate of section 65B of Evidence Act with regard to the conversation alleged to have been taken place between the deceased and Jyotsna is concerned. It is not consonant with provisions contained in 65B clause 4 of the Evidence Act, since the mobile has not been recovered. It is further. This is the relevant page. In the next page, the next page, this is paragraph number 4 paragraph. Considering the entire facts and circumstances of the case, submissions of learned counsel for the parties, nature of evidence, and all attending facts and circumstances of the case, without expressing any opinion on merits of the case, the court is of the view that the applicant has made out a case for bail. The bail application is allowed.
Okay, anything else?
These three.
Yes, Mr. Devchandra.
Lordship, first of all, Lordship, I would submit. Lordship, the petitioner before your Lordship is a uniformed personnel from the CRPF. Although the
No, just a minute. Is this your first bail application? Or on earlier occasion it was rejected by this court?
Yes, Lord.
Where is the rejection order?
Yes. Page number 185.
185.
185.
Okay, okay. Yes, Mr. Devchandra.
Yes. First of all, Lordship, will have to consider he is a person belonging to the CRPF. And apparently, from whatever whether the materials are true, correct, that will come out in the trial. Prima facie, what are the materials against him? Those materials demonstrate his involvement in the activity, Lordship. Now, my friend is on the fact that a notice was served to him on 2nd. He was kept detained and he was produced before the magistrate on 4th. My humble submission before your Lordship is, he was en route from Tripura to Manipur. He is a native of Manipur. So he had taken leave and he was proceeding from Tripura to Manipur via Assam. Now, from Tripura to Manipur, he could have gone very easily. Here, what has happened is, on 2nd, he was served with a notice. Now, your Lordship will kindly consider the NCB office is in Khanapara. Here.
Yes.
And the CRPF camp is very nearby at 9 Mile. At 9 Mile. Now, his difficulty is being a uniformed personnel. He cannot simply evade the authorities unlike any other person. Therefore, on receiving the notice, he had no option but to appear before the authority because being a uniformed personnel, he can be tracked very easily. Now, that is the reason, if I may take your Lordship to page 68 for a moment, that is a part of the CS. Lordship will see on 3/9 he has given some statements and he had made a disclosure of everything, of his involvement. And the materials at page 69 and 70 now, being a personnel of a disciplined force, he was engaging in all these activities. There were transactions. Now, if my friend says there's a violation of section 65 of the Evidence Act, that is a matter for trial, Lordship. That is a matter for trial.
Okay.
And Lordship will see his role, which is depicted in page 151. I'll just read. He's a head constable. Jahia Khan, head constable and radio operator of 124 Battalion CRPF posted at so-and-so, was arrested on 3/9 by the NCB team in Gauhati in connection with trafficking 33.619 kgs of so-and-so tablets. He disclosed that he, along with Abdul Matlib Khan, so-and-so, are supplier of C so-and-so, stated that the receiver of the consignment was Dulal Mia. Jahia Khan instructed arrested accused so-and-so to arrange a carrier to transport. And in all these, he has stated that sometimes he carried. I'll just read out, Lordship. Arrange a carrier to transport the so-and-so tablet from Imphal to Agartala for delivery to Dulal Mia so-and-so near Loknath Ashram, Vishalgarh, ward number 6 so-and-so, for which Rakesh Ahmad was paid rupees 2.5 lakhs. Following this, Rakesh Ahmad arranged CRPF personnel Santosh Kumar so-and-so, he is also an accused, to carry the consignment of tablets. Muhammad Zahia Khan also disclosed that he had earned rupees 25 lakhs through trafficking of tablets. Muhammad Zahia Khan further disclosed that he and Abdul Matlib Khan were regularly supplying so-and-so tablets. Rakesh Ahmed was responsible for arranging the carrier and Dulal Mia is the receiver of the consignment. Zahia Khan disclosed that payments of the trafficking of tablets were made to him sometimes in cash and sometimes deposited in a SBI account. And the whole transaction is there. Now, whether I would say, Lordship, if these amounts which were deposited in his account were by way of some loan or something, that would have been a different thing, an explanation would have come.
No,
He is
okay,
a salaried person, Lordship.
okay, there are incriminating materials against him.
Lordship.
But as regards his submission that he was illegally detained on
That is what my first submission was, Lordship. A notice was served to him. Now, he being a uniform personnel, as I have submitted earlier, Lordship, he cannot simply move around because if he moves around, he will be arrested then and there. He stayed back, Lordship. He's,
where,
I do not know, Lordship. Maybe he has stayed in the CRPF camp that is very nearby, the NCB office. Now, on 3rd, he appears, he gives his statement, and after that, he was arrested, Lordship. That
okay,
is why.
no, his contention is that on 2nd of,
No,
on
Lordship.
the night of
I deny, Lordship.
that,
I deny. I have had a very personal talk face to face with the IO. Lordship, he was there.
Lordship, Lanet.
no, let him complete.
Now, so far as his detail,
That is his sole
that is, Lordship, his submission against mine.
yes,
But-
where have you countered that in your written?
That, Lordship, I do not say that I have arrested him or kept him detained, Lordship. We have served him a notice, that I say. You want to tell us,
11.
What is,
Face of Lordship, section 37(2). Lordship, perhaps may not be inclined to grant me, Lordship. That is my submission, Lordship. Because there are materials, Lordship. Sufficient materials against him.
where is the arrest memo?
$195, Lordship. 195.
Anything else?
That's all right.
Heard
Leave it to your Lordship.
Mr. M. Khan,
M. Rahman, Lordship.
I'm sorry, Mr. M. Rahman,
Lordship,
yes,
my submissions which and I have stated in the petition as in the objection of the Learned and Free Council, nothing has been opposed. All are been my submissions. That means they have not objected in regarding my submission. CDR and 65B certificate
PDR,
and
that
illegal
is,
detention.
that is a legal.
Regarding
submission,
illegal detention, nothing has been
which
objected.
will be handled by the trial court, Lordship.
I have mentioned in my petition in paragraph number 9, he has submitted pairwise objection, but nothing has been objected in regarding this.
In which para you have mentioned about illegal detention?
Paragraph 9, Lordship.
Paragraph 9, Lordship, and the learned NCB council has given parawise reply. Objection. Page number 203, paragraph number 11.
Heard Mr. M. Khan,
M. Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Mr. R. K. Dev Chaudhary, learned Deputy Solicitor General of India, appearing for NCB. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Jahia Khan, who has been detained behind the bars since 4/9/2025 in connection with NDPS case number 13/2026 under section 8 within bracket C/22C/25/29 of the NDPS Act 1985, pending before the Court of Learned Special Judge NDPS Hojai. The gist of accusation.
Lordship, I have submission in written consent submission. May I submit?
Yes, you may give it to me.
Yes.
Gist of a submission. Gist of accusation in this case is Court A from page 186 of the bail application. Learned counsel for the petitioner. No, Mr. M. Rahman, the learned counsel for the petitioner, has submitted that he is not involved in the offense alleged in this case in any manner. He submits that he was arrested on 2nd of September 2025 from Gauhati airport while he was on his way from Agartala to Manipur. Stop. Learned counsel for the petitioner has submitted that nothing was, the contraband in this case, that is 33.617 kgs of methamphetamine tablets, were recovered from one Santosh Kumar Tamil Selvan at Hojai railway station, and nothing was seized from his possession. He also submits that on the date when the seizure was made, in this case, the petitioner was performing his official duty. Where were you?
In Agartala, Lordship.
At Agartala.
My office address is Salbagan, Agartala, Salbagan, Agartala.
he submits that though the petitioner was arrested mainly on the basis of alleged CDR analysis and his bank statements. However, same being electronic records, the prosecution side did not submit any certificate under section 65B of the Indian Evidence Act. Hence, the said electronic evidence cannot be relied upon against him. And on that count also, he is entitled to get bail. In support of his submission, learned counsel for the petitioner has cited a case of which court?
Allahabad.
Of Allahabad High Court. In the case of Munni Devi versus State of UP, within bracket 2023 AHC 196745 bracket close. He further submits that though the petitioner was detained from Gopinath Bordole, Lokpriya Gopinath Bordole International Airport, Gauhati on 2/9/2025 and was produced before the special court only on 4/9/2025. That is well beyond the period of 24 hours within which he should have been produced before the said court. However, he was shown arrested in the arrest memo only on 3/9/2025 at about 17 hours. Hence, he submits that the petitioner was illegally arrested. Petitioner was illegally detained beyond the period of 24 hours, thereby violating his fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India. He submits that on that ground itself, the petitioner is entitled to get bail. On the other hand, Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, has vehemently opposed the grant of bail to the present petitioner. He submits that the present petitioner is a employee of Central Reserve Police Force and the materials on record clearly implicates him in the offense alleged in this case, and sufficient incriminating materials have been collected during the course of investigation. He submits that since the contraband seized in this case is of commercial quantity, the embargo of section 37 of the NDPS Act is applicable to this case. And therefore he may not be allowed to go on bail. He further submits that the arrest memo prepared at the time of arrest of the present petitioner clearly indicates that the petitioner was arrested only on 3/9/2025 at 17 hours. He further submits that it also clearly appears from the documents available on record that on 2/9/2025, the notice under section 67 of the NDPS Act was served on him for recording his voluntary statement, and accordingly his voluntary statement was recorded on 2nd of September 2025 as well as on 3rd of September 2025. And thereafter, after considering the incriminating materials collected and as well as from the voluntary statement given by the petitioner himself, he was arrested only on 3rd of September at 17 hours. Hence, he submits that there is no violation of the mandate of Article 22 within bracket 1 of the Constitution of India. Accordingly, he further submits that the plea regarding non-production of certificate under section 65B of the Evidence Act in support of the electronic evidence produced by the NCB said fact may only be ascertained during the course of the trial, and this is not the appropriate stage to consider the said plea. Accordingly, he submits that the prayer for bail of the petitioner may be rejected. I'll go through the records and pass the orders in chamber.
Yes.
The chamber of the Bukita. I'll pass the orders in chambers.
Daily list, admission, section 1.
One mention করেছে তো।
Sorry, item 2.
Yes,
May I plead, Your Lordship, it's that testamentary appeal, kindly appeal may be admitted, Your Lordship.
yes,
Yes, appeal may be admitted. And the record may be called for. And they may be directed to file a copies to us. And I further pay that the
heard miss.
immediately after receipt of the record, it may be put up for orders.
What is the name?
It's Z Daisy.
Heard Miss Daisy, learned counsel for the appellant. Also heard Mr. A.C. Sharma, learned senior counsel assisted by Mr. G. Bhardwaj, learned counsel for the respondent. This appeal under section 299 of the Indian Succession Act, 1925 has been filed by the appellant Shri Leeladhar Das, impugning the judgment and order dated, whether probate was granted or not granted,
Not granted.
not granted.
Sorry, granted. Probate granted.
Impugning the judgment
our-
and order dated 1/10/2024, passed by the Court of London, Additional District Judge Borpeta, in title suit within bracket probate number 3/2024, whereby the probate application filed by the present respondent was allowed. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. The appeal is admitted. Let the records of title suit within bracket probate case number 3/2024 be called for from the trial court. The registry shall take steps for requisitioning the records. Since Mr. Ashish Sharma, learned senior counsel, has already appeared for the sole respondent, no formal notice need to be issued to this said respondent. List this matter accordingly on 2nd of June.
Bless your lordship.
Item 3.
Yes,
May I please, your lordship, this is a regular first appeal against the judgment and order dated 6/8/2024, entitled suit number 17 of 2017. What happened, my lord? There is an agreement, the plaintiff filed the suit,
why it has been listed today?
your lordship.
Whether the respondent has appeared.
Yes, your lordship. The sole respondent already appeared. Previous day, he also appeared.
Then why it is listed in admission column? The appeal has already been admitted.
No, your lordship.
It has been admitted on the last date.
That's it, but only the stay order is, interim stay is granted.
Interim stay has been granted.
Only. Previous day, 6/3/2024.
Where? In a separate IA is there.
Yes, your lordship. I am
Yes.
number
I
7/16.
records I think. Not Miss B. Sarkar, learned counsel for the appellant. None has appeared for the respondent, though on last occasion, learned counsel representing the sole respondent had appeared. It appears that the appeal is against what?
First, there is an agreement to sell. On the basis of that, the respondent has paid 10 lakhs. The petition plaintiff has stated, but the man, I have.
No, you are impugning which order?
Judgment and order dated.
Okay, we'll call for the records. It appears that though the appeal was admitted on 6/3/2026, however, the records of the trial court have not yet been requisitioned, which would be necessary for consideration of the instant appeal. Accordingly, let the records of title suit number 70/2017 be called for from the trial court. Registry to take steps for requisitioning the records. Let this matter be listed on 10th of June.
Your Honor,
The interim order granted earlier in interlocutory application number 716/2026 shall continue till next day.
Item number 4.
Yes, Mr. Bhatto.
An appeal filed by the insurance company. Two vehicle was involved in the accident. Entire liability was passed upon the insurer of one vehicle. And we have challenged the quantum of award also.
Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Mr. G. Bhardwaj, learned counsel for respondent number
1 and 2.
1 and 2, as well as Ms. N. Chaudhary, appearing for respondent number and respondent number 5. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by New India Assurance Company Limited, impugning the judgment and award dated 30/7/2024 passed by the Motor Accident Claims Tribunal Dhubri in MAC case number 245/2017, whereby the appellant was directed to pay a compensation amount of rupees 61,47,000 along with an interest at the rate of 7% per annum to the claimants respondents. Mr. Bhardwaj is appearing for?
Respondent number claimants.
Okay, issue noticed. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. The appeal is admitted. Issue notice to the respondents. Since Mr. Bhardwaj has appeared for respondent number 1 and 2, and Ms. Chaudhary has appeared for respondent number 5, no formal notice need to be issued to the said respondents. However, as regards respondent number 3, 4, and 6, the appellant shall take steps for issuance of notice on the said respondents by speed post as well as by usual mode within 7 days of date of this order, returnable on 14th of July. 14th of July na? May Mahodyo. 22nd May. 22nd of May. List accordingly.
A put a stay subject to minor deposit of 50%.
You deposit 50%. Only deposit.
No matter, then I'll file an application.
Okay. Heard Mr. K.K. Bhatto, learned counsel for the applicant. Also heard Mr. G. Bhardwaj, learned counsel for claimant respondent, as well as Ms. M. Chaudhary, learned counsel for respondent number 5. This application under section under order 41 rule 5 of the Code of Civil Procedure has been filed by the applicant insurance company within bracket New India Assurance Company Limited in connection with why this application 1 140 has been filed.
What's it? The execution case was filed. To the typing.
And what is 823? IA 823.
It was, Lordship, delay was not condoned at that time, so when I filed that case, Lordship, that is why.
Okay. Now delay has been called.
Yes.
In connection with MAC appeal number 161/2025, praying for stay of execution of the judgment and award dated 30/7/2024, passed by the Motor Accident Claims Tribunal Thubri in MAC case number 245/2017. Stop. The aforesaid judgment has been impugned by the present applicant in the connected MAC appeal. Learned counsel for the applicant submits that the claimant respondents have already initiated an execution proceeding in form of money execution case number 3/2025. Stop. He submits that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. Since learned counsel for the claimant respondent has conceded to the prayer of the applicant for stay of execution subject to payment of 50% of the awarded amount, notice to respondent number 3, 4, and 6 is hereby waived, and this interlocutory application is allowed. The execution of the impugned judgment and award dated 30/7/2024, passed in MSC case number 245/2017, in the money execution case number 3/2025 shall remain stayed during the pendency of the connected MAC appeal number 161/2025, subject to the condition that the applicant insurance company shall deposit 50% of the awarded amount before the registry of this court within a period of 6 weeks from the date of this order.
4 weeks, no, 6 weeks.
This interlocutory application is accordingly disposed of.
Value.
Yeah, item number 3, I was for solved. My name is.
Item number 3, show the presence of Mr. J. Laskar for responding. We have already passed order. J. Laskar for responding.
Moving to the item 43.
The petitioner before appellant before lordship is APDCL. We have challenged the judgment and order dated 6/3/2026, whereby lordship we were directed to pay 10,75,100 rupees, and we have deposited the amount which comes to 22,14,637.
What is the substantial question of law?
Then your lordship will find at page number 3. Lordship, a direction was made, the claimant claimed that the deceased workman was receiving salary of 15,000. We denied it in the written statement, saying that there was no certificate or salary certificate was submitted by the deceased workman. And then an application was claimed to be filed by the claimant's lordship, wherein a direction was made to the APDCL to produce the instruction in respect of the income of the deceased employee. We produced it saying that he was receiving salary of rupees 7,200, which is in terms of the minimum wage notification issued by the APDCL, which is in compliance of the notification issued by the Ministry of Employment. So that was not considered, and it was wrongly considered to be 15,000, not cheap.
Heard Mr. P.N.
R Bora, not cheap.
Sorry, heard Mr. R. Bora, Learned Standing Council, APDCL. This appeal, Learned Standing Council, APDCL, for the appellant. Stop this appeal under Section 30 of the Employees Compensation Act 1923 has been preferred by the appellants, impugning the judgment and order dated 6/3/2026 passed by the Learned Commissioner, Employees Compensation, Kamrup Metro in EC case number 18/2022. Whereby the appellant was directed to pay how much compensation?
10,75,100,
Pay a compensation
pay 78, not cheap.
amount of rupees
75,000,
10,75,100
100.
to the claimant respondents. Stop. I have considered the submissions made by Learned Counsel for the appellant and have gone through the materials available on record. After considering the submissions as well as materials available on record, following substantial question of law is formulated in this appeal. Whether the judgment and award passed by Learned Commissioner, Employees Compensation, Kamrup Metro in EC case number 18/2022 is hit by perversity in ignoring the material evidence available on record while coming to a finding that the monthly income of the deceased workman was rupees 15,000. Stop. Question mark. This appeal is admitted. Let the records of EC case number 18/2022 be called for from the office of the Employees Compensation, Kamrup Metro. The registry shall take steps for requisitioning the aforesaid records. Let the notice be issued to respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on May 22nd May.
Document grant us 2 weeks time because since there is holiday, we
Instead of 7 days, 7 working days.
not.
No, instead of 7 days, 15 days time.
But when I is there, not.
I will issue notice. Let the other side come.
I think we have already deposited the amount. If they withdraw it, then this entire exercise will be meaningless.
Not meaningless. If they are not found entitled, they will redeposit it.
Not sure.
How it will be meaningless?
Not sure.
We'll issue notice.
Not sure.
Issue notice to the respondent.
Daily list, orders, item 7.
May please, my lord, in this, my lord, I have filed an IA, my lord, but that IA has not been tagged, my lord. My lord, can it be listed after vacation with the IA, my lord?
Heard Mr.
Peace only, my
P. Sundi. Why your name is not there?
My lord, I have filed the power, my lord, but it has not been shown, my lord, that my name may be
Heard
shown. my lord.
Mr. P. Sundi, learned counsel for the appellant, who submits that the appellant has filed an interlocutory application in this appeal. However, same is not placed along with the records. He prays for calling the same. Stop. The registry is directed to list this appeal again on
27th of
27th of April, along with the interlocutory application filed by the appellant.
Much of
Item number 8.
No, they have appeared, so Lordship may fix it for hearing in the usual course. Otherwise, the appeal is admitted. I was directed to take steps upon the respondents through the state, which I have taken also from the affidavit.
You are appearing for both of
Both respondents.
both the respondents. Heard Ms. Aidas, learned counsel for the appellants. Also heard Mr.
As they.
SD appearing for both the respondents. Records have arrived.
Seems so much.
What you are impugning?
Lordship, with the order, the injunction order, Lordship.
Let this matter be listed for hearing when? July.
Lordship may.
Hearing on
14th July.
14th of July.
Deeply obliged.
Deeply obliged. Item number 9.
It be resolved. Lordship, I have taken steps to them upon the respondent.
Heard Mr. A. Deka. Heard Mr. A. Deka, learned counsel for the. You have not taken steps.
Today I have taken steps now.
Learned counsel for the applicant, who submits that he has taken steps for issuance of notice upon the respondents today only, and therefore some time may be granted, and therefore the service report may be awaited in this case. Stop. Let this matter be listed again on
29th May.
29th May.
Okay.
Item number 10.
May I please? As per office note dated 4/4, the service upon respond number 1 is awaited. It is an application under section 5 of the Limitation Act for condoning the delay of 22 days. Respond number
When
one-
have you taken steps?
That is twenty-five to 26 by both ways.
Now what is to be done?
But, since he's the driver, at this stage, my lord,
No, delay condonation notice has to go to every respondent. Heard Mr. A. Bhattacharya, learned counsel for the applicant. Also heard Mr. K. Bhatta, learned counsel for the respondent number 3. When have you taken steps on one?
25/2.
Learned counsel for the applicant submits that in pursuant to the directions of this court, the applicant has taken steps for issuance of notice upon respondent number 1 on 25/2. However, the said notice has returned with a postal remark within inverted comma insufficient address return to sender. What is the ground in your connected appeal?
I have come against the dismissal of my claim petition.
You are claiming?
I am claiming.
Yes, Mr. Bhattu.
Lordship, I have not find their memo appeal, Lordship. I don't know what is the ground in the appeal.
No, notice has to go to the driver.
Since the other postal receipt is yet to receive, my lord, can we wait for some time?
Other means?
My lord, I take both steps, steps by both ways. Obviously,
Usual
for
mode.
last line, my lord, yet to receive. One is Talabana and the other is this one, speed post.
Oh, in last line katiba itu 2025 or asile. Without last paragraph ki asile. Ito rakhi do. The registry is directed to place the postal track consignment report of the notice issued to respondent number 1 by speed post on the next date fixed. Let this matter be listed on 28th of April. 28th of April.
Public.
Item number 11.
Lordship, as per original ticket 4426, Lordship, notices were issued to respondent number 2 and 3. One has already appeared. So the Satya service may be awaited, Lordship.
Heard Mr. A. Jeswakya, learned counsel for the applicant. Also heard Mr.
NZ Chaudhary.
N.Z. Chaudhary, appearing for learned counsel for the respondent. The service report in respect of notices issued to respondent number 2 and 3 is awaited. From the registry is directed to place the postal track consignment report of notices sent to respondent number 2 and 3 by speed post on the next date fixed. Let this matter be listed again. 28th May.
Of my Lordship.
Item number 12.
Thank you, Lordship. Here the steps have been taken by on 19/3/2026. However, the service report is awaited.
But Mr. What is your name?
R.A. Locker.
R.A. Locker, learned counsel for the appellant. Peruse the office note dated 2/4/2026, indicating that service report in respect of notices sent to the respondents is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to respondents number 1 and 2 by speed post before this court on the next date fixed. Let this matter be listed on 6th of May.
Oblige.
Yeah, please, your lordship.
Yes.
Respondent number 1 has expired, so we need some time to. file
You are
our-
appearing for
For the respondent number 2.
respondent number 2.
No, no, one.
How many respondents are there?
3 respondents.
For respondent number 1, on the last occasion, I informed the court that respondent number 1 has died. We have procured her death certificate, but with certain spelling mistake in her husband name. So we have sent it for rectification.
And
Some time is required to file the.
you are also appearing for 2.
No, for 1 only.
Okay.
Respondent number 2 and 3 has been struck off as per order dated 23/2/2026.
What is your name?
Mr. S. Shom on behalf of.
Heard
Mr.
Mr. S. Shom, learned counsel for the appellant. Also heard Mr.
S. Nag.
S. Nag, learned counsel for respondent number 1. Who submits that? Respondent number 1, stop. Learned counsel for the appellant prays for some more time for taking appropriate steps for substituting the legal heirs of deceased respondent number 1. The prayer is allowed. Let this matter be listed. ECMA. No, in the month of May.
June.
Oh, okay,
because we
8
require
8 June.
it.
Let this matter be listed on the June.
Like,
I am taking a.
May please lordship. Hello, the office note dated 6/4/26.
Yes.
The respondent number 1 already appeared. It is something, my lord.
2.
mistake. 2 and 3 I took step, but showing the 2 is insufficient address, because as per the claim petition, I have prepared this my memo petty. So, my lord, that is the responsibility of respondent
No,
number
Lord,
1.
why I should,
Because
keep the voice.
you have.
no, whatever I have found from the police record, I have given that.
Then otherwise, my lord, this is correct
Then
address.
Your text for substitute service, justice service or any other
I
mode.
have taken both ways. as
This
per
is
this-
your appeal
As per this order of this honorable court.
for paper publication.
But my lord, there is no reflection regarding the respondent number 3. Because owner and driver.
Postal tracking,
When have you taken steps?
Well, I have
on
taken
respondent
step.
number 3,
Long back, my lord.
9/3,
I have taken step on, my lord,
6/3. Okay.
27.
Okay, as regards respondent number 2, you have to take alternate steps by paper publication. And respondent
Well,
number,
I have taken in both ways. I do not know here is reflection on the
both ways means
usual post and speed post. But not mentioned.
usual process has not written. We may await.
Yeah. Even then, my lord, maybe given direction, respondent number is not shown. See, any report.
Heard Mr. R.C. Paul, learned counsel for the appellant, also heard Mr. A.R. Agarwala appearing for respondent number 1.
Clement.
Claimant. The office note dated 6/4/2026 shows that the unserved notice issued to respondent number 2 has returned with a report with a postal endorsement within inverted comma, incomplete address returned to sender. However, the notice issued to the said respondent by usual mode has not yet returned. Await service report in respect of notice issued to respondent number 2 by process server. Stop. Registry is also directed to place the postal track consignment report of notice sent to respondent number 3 by speed post on the next date fixed. May Mahoti. Late 15th of May.
Slight in IL lordship, slight mistake. If owner's lordship, lordship, that may kindly be seen whether I have to file this IA or it can be rejected. Slight mistake only. IA civil 3025. Only slight mistake in respect to pair number 7, the clerical mistake lordship.
I number
302525.
3025. What is this I?
In the pair number 7 lordship.
No, what is this I for?
This is for stay and this release of 50% lordship. In pair number
No,
7.
you have paid for stay.
I have paid for say, this article was placed to state, subject to payment of 50%.
You have
There
paid.
is some mistake, 1 to 4. 1 slash, there is some mistake, that is not released.
There is no
Because
for,
only one, respond number 1 is claimant.
I am for 1 only. 2 and 3 are owner driver and 4 there is no such respondent. Pair number 7 lordship.
Pair number 7 of
This
Order.
Order lordship, order dated 23 to 26. That should be to be done by the respondent number 1 claimant. Only 1 claimant, injury case lordship.
pair number
7 lordship.
7, which page?
Page number 3 lordship.
3 of this I.
Yes, lordship. Of this order lordship.
Which order?
23 to 20.
Where is that order?
The IA,
In the IL the lordship. IA 3025 lordship.
IA 3025.
order
We-
dated 23 to 26.
Or 23 to 20.
My lord,
This I has been disposed of.
Yes, lordship.
yes.
Then an interlocutory application has to be filed. Because where I will pass orders. I cannot pass orders in a disposed of case.
Yes.
You file an I'll rectify it.
But I have
But-
to file this IA lordship.
Somewhere I have to pass an order.
In the appeal lordship in IAS, then they will release the amount lordship. Yes. In the appeal mentioning this IA number. If possible, lordship, other than file. Whatever lordship will suggest.
Appeal from. Appeal क्या लिखा last time. So, Learned counsel for the respondent number 1 has submitted that in the connected interlocutory application, that is IA number 3025/2025, which was disposed of on 23/2/2026, whereby the claimant was allowed to withdraw the 50% of the deposited, 50% of the awarded amount, which was deposited by the
Appellant insurance company.
appellant insurance company, comma, a typographical error has crept in in line number 2 of paragraph number 7 of the aforesaid order. Learned counsel for the respondent number 1 submits that in line number 2, as there are how many how many,
Only one.
as there is only one
Claimant.
claimant, that is respondent number 1. The mention of respondent number 1 to 4 in the said line is a inadvertent typographical error and same needs to be rectified. Mr. R.C. Paul, learned counsel for the insurance company, fairly submits that as there is only one claimant in the connected MAC in this case, hence the mention of 1 to 4 in mention of respondent number 1 to 4 in paragraph number 7 appears to be typographical mistake and same read needs to be corrected. Accordingly, it is hereby directed that in line number 2 of paragraph number 7 of order dated 23/2/2026 passed in IA number 3025/2025, the words within inverted comma respondent numbers 1 to 4 / claimants inverted comma close shall be read as respondent number 1 only.
From the one / claimant.
Respondent number 1 / claimant only. The deposited 50% amount may accordingly be disbursed to respondent number 1 / claimant by the registry after proper verification.
Item number 15.
May I please, Your Lordship? As per office note dated 4/4/26, Your Lordship, service upon respondent number 5 is still awaited, Your Lordship. Take dusty service upon respondent number 5, Your Lordship.
You will
Yes,
you will take the
yes,
service.
sir.
Heard Miss S. Nazneen, learned counsel for the applicant. Also heard Mr.
S Kathak, Lordship. For
S.
respondent number
Kizo,
three. S Kathak,
S. Kathar,
for respondent number 3.
learned counsel for respondent number
3.
3. On perusal of office note dated 25/2/2026,
Your Lordship, 4/4.
sorry, 4/4/2026, it appears that notice to respondent number 5 has not yet returned. We can call for postal track consignment report.
Yes, Your Lordship.
Thereafter, you take
Dusty
the
service.
The registry is directed to place postal track consignment report of notice issued to respondent number 5 by registered by speed post before this court on the next date fixed. Let this matter be listed on 13th of May.
Bless you, Lordship.
Item number 16 with item number 46.
48, 48. May please, yes, my lord. My lord, this matter, my lord, has been wrongly listed in the orders column. It ought to have come for admission hearing, my lord. This is the first appeal, my lord. My limited period is that let this appeal may be admitted. Already the item number 48, that is already admitted, 48. Item number 48 was already admitted, my lord, by order dated 7/6/3 to 25/2/2026, my lord. Both the appeals are arising out of connected, my lord, same judgment and order.
Heard Mr. G. Imtiaz,
Iqbal.
sorry, A. Iqbal, learned counsel for the appellants. Also heard, Mr.
DJ Boro Lordship in item number 48.
And in item number 16,
16 Lordship, I will,
It's same
Take-
parties, my lord, same.
I will take, I will accept notice Lordship.
also heard Mr. DJ Boro,
Yes, Lordship.
only sole respondent
Two respondents.
Two respondents.
for both your appeal,
Yes, Lordship.
who appears for both the respondents. This appeal under section, and this appeal under
96.
where is the memo of appeal? Under section 96 of the Code of Civil Procedure, 1908, has been preferred by the appellants, impugning the judgment and decree dated 25/11/2025, passed by the Court of Learned Civil Judge Senior Division, Golaghat, in title suit number 12/2025, whereby the title, your suit was dismissed,
My suit was dismissed and their counterclaim was.
whereby the suit filed by the present appellants was dismissed and the counterclaims filed by the respondents
Partly allowed.
was partly allowed. I have gone through the memo of appeal. And considered the submissions made by learned counsel for the appellants. This appeal is admitted. Let the record of title suit number 12/2025 be called for from the trial court. Since Mr. DJ Boro has appeared for both the respondents, no formal notice need to be issued to the respondents. Please, this matter. In 48 records have come.
Records have not come, actually.
List this matter along with RFA number 18/2026 on 14th of July 20.
Well, there is an IA also.
Lordship may furnish a copy.
I'll give them. Today itself.
The appellants are directed to furnish a copy of memo of appeal along with annexures to the learned counsel for the respondents within a period of 2 days from this order. Ayatu Sam, Ramesh. What is, what for?
It's for my lord staying the judgment and decree, my lord, because the court has passed an order directing me to pay an amount of rupees 12 lakhs. And then,
Have you filed execution?
Lordship, that I have no.
You have to take instructions.
Yes,
Let them take instruction.
because Lordship, I have not received any notice, Lordship, in this case. Item number 16.
Okay. In I heard so and so, I number 715, so and so, learned counsel for the, no, the applicants are directed to furnish a copy of this interlocutory application along with annexures to the learned counsel for the respondents within a period of 2 days from the date of this order. List this matter again along with the connected RFA on 14th of July.
well, may I plead that I may be taken up last week of May if they filed, my lord, then.
Yes, May last week. 29th May.
Deeply of-
29th. In item number 48,
40 no IA.
item number 48 of Likhibo, heard so and so, both parties are present. List this matter along with RFA number
20 of 2020.
20/2026 on 29th of July, 29th of May.
Deeply of
Lordship.
Item number 17.
Yes,
Lordship, the steps have been completed.
I am appearing for respondent number one, Lordship, the owner of the vehicle.
how many respondents are there? Two.
I haven't received the memo of appeal, so I don't know.
Lordship, two respondents.
Only two. What is your name?
Aristo Narzadu and the
No, no,
HDF.
Tuman Nam.
Sorry, S Das.
Heard me, Mrs. Das, learned counsel for the appellant. Also heard Ms. R.D. Mujumdar appearing for respondent number one.
Lordship, with humble request. In MSc appeal cases 108/2026, 593/2025, and 63 of 2026 arising out of the same accident. Kindly all the matter may be taken.
I will take you order winner. That's a type code.
Okay. On perusal of the office note dated 6/4/2026, it appears that the notice issued to respondent number two has not yet returned. The registry is directed to place the postal track consignment report of notice sent to respondent number two by speed post before this court on the next date fixed. The appellant is directed to furnish a copy of memo of appeal along with annexures to the learned counsel for respondent number one within a period of 2 days from the date of this order. Learned counsel for the appellant submits that there are 3 other MSc appeals, namely, yes,
108 of 2026, 593 of 2025, and this MSc appeal 63 of.
two other MSc appeals arising out of same accident, namely so and so, and praise for listing those appeals along with the instant appeal. The prayer is allowed, registry to do so. Let this matter be listed on 20th of May.
Item number 18.
Your Lordship. My lord, as per office noted 6/4/26, Lordship. Service report upon respond number 1 to 3 are awaited, Lordship.
Heard Ms. M. Chaudhary, learned counsel for the appellant. On perusal of the office note, it appears that service report in respect of notices issued to respondents are awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to respondent number 1 to 3 before this court on the next date fixed. Let this matter be listed again on 20th of May.
Most obliged, Lordship.
Item number 19. May I please, Your Lordship? Your Lordship, as per office note, service report is awaited.
Heard, Mr. What is your name?
As Islam appearing on behalf of M. Khan.
S. Islam, learned counsel for the appellant. On perusal of the office note, it appears that the service report in respect of notice issued to, how many respondents are there?
One, Your Lordship.
To the sole respondent is awaited. Only one respondent. Is awaited. The registry is directed to place the postal track consignment report of the notice issued to respondent number 1 by speed post before this court on the next date fix. List this matter on
22nd May.
22nd May.
Oh, bless it. Item number 20.
Made. One of these appeal was admitted on 25/2/2026, my lord. And notices were issued as per office note dated 6/4/2026, my lord. The respondent one is served. Respondent two notices were received by the mother. And three also, my lord, served. Respondent four is received by the wife. So 1, 2, and 3 are the claimants.
Okay.
And 4 is the honored cum driver.
Heard Mr. R.K. Bhatra, learned counsel for the appellant. On perusal of the office note dated 6/4/2024-26, it appears that notices issued to respondent number 1, 2, 3, and 4 have been duly served. I have perused the report of the process servers annexed along with the record, which indicates that notices issued to the respondents are duly served. Accordingly, the service of notice on all the respondents is complete. The records of MSC case number 1257/20 has not yet been received. Registry to issue reminder for the same. List this matter again
29.
on 29th of May.
My lord, I have a submission, my lord, as regard like the IA, my lord, 5. Lord,
Sir.
only notices were issued in this case.
No, whether they have filed any execution case.
My lord, they have not filed, but my lord, we are ready to deposit, my lord,
Okay.
20% of the awarded amount.
20?
20%.
Why?
My lord, this is a compassionate and a family scheme. The dependents are getting the entire, my lord, the whatever salary he was drawing, the last drawn salary of the deceased. So only they are entitled to the conventional heads.
No,
medical
whether they are
expenses.
getting or whether that notification was implemented or not.
Yes, ma'am. But after 2017, my lord, this, my lord, it has been taken effect of. And the accident had occurred sometime in 2020, my lord. They are entitled to, my lord.
Yes, they are entitled to, but whether government is.
Well, even though they have not applied or they are not, my lord, been given, then also the liability will not come on the insurance company, my lord, because the double benefit they cannot draw, my lord.
Yes, double benefit they will not get.
Yes,
But for that, they have to get one benefit.
exactly, my lord. Lordship is aware about the Supreme Court decision of Birendra, my lord.
You deposit 50%.
My lord, that will again become a very difficult proposition, my lord. In that case, I will not, my lord, press for a stay at this stage.
Then
Let them appear.
let them appear. On the
My lord, because they are entitled to the conventional heads, the medical expenses and the future prospect which accrued.
how much it comes?
It comes to 30 lakhs and odd, my lord. So if 81 lakhs is the award, if you deposit, well, that will be covered. So on the date of their appearance, they can file an application and take away the amount. Rest they can approach the government.
Against conventional heads, it comes to
1,81,000. I have just calculated, my lord.
how much it comes?
Conventional head is 1,81,500. Medical expenses is 2,17,000.
And lot,
Someone calculate it.
yes, my lord, we have done it.
How much it comes totally?
25 lakhs plus वो कर लो, add कर लो. 25 lakhs 86,480. 480 plus. Yes, plus. 29 lakhs 85,933, my lord. This is the exact figure. My lord, I submitted 30 lakhs. So, my lord, if 20% is allowed to be deposited by the company.
You deposit 30 lakhs.
30 lakhs, okay, my lord. As your lordship, please.
Art Mr. R.K. Bhatra, learned counsel for the applicant. None has appeared for the opposite parties, though in the connected MSc appeal, the notice issued to the opposite parties are no, you have taken steps in this case also, no?
IA also.
I also.
Yes, ma'am.
Though the notice issued to the opposite parties have been duly served as reflected from the report of the process server in the connected MAC appeal number 74/2026. Learned counsel for the applicant submits that since in the connected appeal, the insurance company has taken the plea that in view of the government notification whereby the dependent of the deceased would continue to get the complete salary till the remaining period of his service, there is no loss of dependency of the claimants, and against the said head, they may not get any compensation. He submits that the compensation awarded to the claimants under conventional heads comes to the total of approximately 30 lakhs.
Conventional head will be only 1,81,000.
And other
Other are the medical expenses.
conventional
and
heads,
future prospects.
conventional heads, compensation awarded to the claimants under conventional heads, against medical expenses and future prospects comes to approximately about 30 lakhs, which the insurance company is ready to deposit before the registry as a condition for grant of stay of the execution of the impugned judgment and award. After considering the submissions made by learned counsel for the applicant, this court is of considered opinion that the same appears to be fair, and hence this interlocutory application is disposed of with a direction that during the pendency of the connected MAC appeal number 74/2026, the execution of the impugned judgment and award dated 4/11/2025 passed in MSc case number 1257/2020 by the Motor Accident Claims Tribunal number 1 Kamrup Metro shall remain stayed subject to deposit of an amount of rupees subject to deposit of an amount of rupees 30 lakhs out of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of. You can take it back.
DP applied.
Item number 21.
May I please, your lordship, according to office note dated 4/4/26, lordship, AD card or unserved notice of respondent to not yet received, lordship.
When have you taken steps? Two, okay. Heard, Miss M. Setia,
Yes, it is.
sorry, B. Sutia, learned counsel for the appellant. Also heard Mr.
S. Kathak lordship.
A. Kathar,
S. Kathak lordship.
H. Kathar,
Respondent number 1.
learned counsel for respondent number 1. Office note dated 2/3/2026. Office note dated 4/4/2026 shows that the the service report of in respect of notice issued to respondent number 2 is still awaited. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post before this court on the next date fixed, May 8th May. Let this matter be listed.
Item number 22.
May I please, your lordship? As per office noted dated 4/4/26, no AD card and answer notice upon the sole respondent.
Heard, what is your name?
A. Banerjee.
Heard Mr. A. Banerjee, learned counsel for the appellant. On perusal of the office note dated 4/4/2026, it appears that the service report of notice issued to respondent is still awaited. Stop. The registry is directed to place postal track consignment report of notice sent to respondent by speed post before this court on the next date fixed. List this matter on
8th of May.
8th of May.
Item number 23.
May I please, lordship, lordship, as per the office note dated 6/4/2026, the service for the respondent number 1 to 4 are awaited.
Heard Mr.
Ekakoti, lordship.
A. Kakoti, learned counsel for the appellant. It appears from the office note that the service report in respect of notices sent to all the respondents are awaited. Stop. The registry shall place the postal track consignment report of notices sent to all the respondents by speed post before this court on the next date fixed. Let this matter be listed on.
Lordship, and lordship, there is an IA for stay, lordship. Stay was granted, but the stay petition was not disposed of, lordship. It was subject to the deposit of the 50% awarded amount, lordship.
You have
and it already
deposited
deposited, lordship.
stay petitions on. And to stay petition delay.
IA number 650/26, lordship.
No, let it remain. So that when the other side appears, if they pray for dispersal, we can dispose it of.
Obliged, Lordship.
Item number 24.
This is your lordship. We have taken steps on 6/4/26 lordships. So I think the track consignment just 2 days back. So the
Heard
registration.
Ms. Hadi Majumdar, learned counsel for the applicant, who submits that the applicant has taken steps for issuance of notice upon the respondents by speed post on
On
See.
both ways, lordship.
Speed post as well as by usual mode on 6/4/2026 only. Hence, same is not reflected in the office note. Stop. In view of submissions made by learned counsel for the applicant, the registry is directed to place the postal track consignment reports of notices sent to the respondents by speed post before this court on the next date fixed. Let this matter be listed on
20 May.
20 May.
Highly obliged.
Item 25.
None has appeared for the applicant on call. On perusal of the office note dated 4/4/2026, it appears that notice issued to respondents have not yet returned. The registry is directed to place the postal track consignment reports of notices issued to respondents by speed post before this court on the next date fixed. Let this matter be listed again on 20th of May.
That's 25.
Show the presence of Mr. A.R. Agarwal.
Postal track consignment.
I have ordered.
Much good. I'll let little submission allowed. In fact, I had instructed my colleague to make a mention at 10:30. Now we have taken consent from the other side, item number 41, my lord, maybe.
40.
41. Can it be taken after vacation?
Yes. Heard Mr. R. K. Bhatra, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. D. K. Kolita,
Respondent number 1.
learned counsel for respondent number 1, who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed. 5th of
Okay.
Item 44, please add to.
May it please your lordship, my lord. This is the second bail application. On the last occasion, my lord, when we moved the bail application, my lord, we did not state in the affidavit the filing of the bail application, my lord, because the person was in custody, we did not have the proper instructions. And after getting the the instructions from the petitioner's side, my lord, we could obtain the particulars of that bail application. My lord, your lordship will kindly find that in the additional affidavit at page 144. But prior to that, your lordship will kindly take note of the dates, my lord. The FIR was filed on 19/5/2005. 19/5/2025. Then I was arrested on the same day, on 19/5/2025. and till today I am in custody for 10 months and 20 days. Then, my lord, the charge sheet was filed. But prior to filing of the charge sheet, my lord, the first application was filed on 18/6/2025. Your lordship will kindly take note of the date. That is prior to filing of the charge sheet, my lord. The first bail application was filed on 18/6/2025. And on 26/2025, after 2 days of the filing of the bail application, the charge sheet was submitted on 20th of June 2025, and the charges were framed on 2/9/2025. Now, your lordship will kindly see in terms of your lordship's order dated 23/3/26 at page 158. It is in your lordship's order sheet also, but we have annexed your lordship's order. In terms of the order, we are required to file the affidavit. And in the affidavit, my lord, we have annexed the earlier bail application, my lord. Your lordship will find from page 148, the bail application, my lord. It was filed prior to the filing of the charge sheet. That's why when it was pointed out by the before this honorable court that the charge sheet has been submitted. So without discussing anything on the merit, my lord, your lordship will find the earlier bail order at page 155, 155.
Yes.
Now your lordship will see the order. Your lordship's order it is. Heard Mr. K. Thakur, learned counsel for the petitioner who prays for withdraw, allowing the petitioner to withdraw the instant bail application. Prayer is allowed. The bail application is accordingly dismissed on withdrawal. There was no discussion on merit. There was nothing. It was a simply withdrawal because in the meantime, the charge sheet was submitted on 20th/6/2025. So the withdrawal order was done on 4/8/2025. Then thereafter, we filed another bail application before the honorable court. And we had also an opportunity to argue on the basis of the charge sheet that was filed, but that was rejected. Now, let us come to the to this case, my lord. Your lordship will find now out of the prosecution witnesses, my lord, out of the total 6 prosecution witnesses, my lord.
Yes.
The mother of the victim girl, the victim, her aunt, the doctor has already been examined. 4. And out of that, my lord, since the observation of there was no effective cross-examination of the doctor, and my lord, the person was in custody, we filed an application for re-examination of the doctor that was allowed. Now, on the last date, my lord, when we went for cross-examination during the pendency of this bill application, when we went for cross-examination of the doctor, he could not turn up, including the investigating officer, due to the election season and all. So the next date is fixed in the trial court for on 30th of this month for cross-examination, further cross-examination of the doctor and the investigating officer. So far, the father is concerned, the prosecution does not want to cite the father as a witness. That is the discretion of the PP. So that is the stage of the trial. Here today, I am not asking your lordship to determine on the merits of the case, because any order passed now on the merits of the case will prejudice either my case or of the prosecution. Here, your lordship will knows that when a person is sick, when he is old, there are some special consideration for consideration of his bail. The person who is before your lordship is 73 years old. So your lordship will first point out to his medical documents, because that is the first 2 grounds. On the one is that he is a senior citizen of 73 years old, and his medical condition I will refer from page 51.
Page 51.
51, Annexure 10.
Yes.
Now your lordship will shift to page 53.
Yes.
Now your lordship will see at page 53. This is the hospital record of Narayana, on which is where he has been cited as a 71 age 20. It was of 21/4/2025. So diagnosis, your lordship will find heart failure, hypertension, LBD, type 2 diabetes, mellitus, primary final. Then your lordship will see on the note that is cardiac 1, 2, 3, 4, 5, 6 to continue cardiac medicine. Then procedure history, that it is orthopedics, neurosurgery, all this have been referred to. Then in the next page, my lord, as page 55.
Yes.
Page 55, your lordship will find the left ventricle, mild LV systolic dysfunction, grade 1 LV dystolic dysfunction, mild concentrated. This is that means the heart main chamber is weak in pumping and it is mildly thickened. That is the medical term, but it is the heart condition is not good. Then your lordship will find, look at page 56.
Yes.
Wall motion abnormalities, your lordship will find hypokinesia of the distal anterior septum, that is weakness of the heart muscle. Then findings is all about blockage and narrowing in heart arteries, and therefore there is a coronary heart problem. And your lordship will find that it is a if your lordship looks into finding, your lordship will find that these are all of previous heart attacks. Now your lordship will then go to the next page. Heart is weak. I will refer to his heart operation also. The next is your lordship will find even his kidneys are not functioning properly, my lord. Your lordship will find at page 57. Page 57, the last one, indicative of renal impairment less than 60%. That means the kidneys are not functioning properly. The result is should have been is not within the parameters that they have indicated. Then at page 55, there is a note that abnormal results are highlighted in case of kidneys. Then your lordship will look at page 59. Page 59, your lordship will find HbA1c is 7.9. Because when you have diabetes, blood pressure, the kidneys, heart will all go. That's why at page 60, your lordship will again find this is also abnormally high. It should have been less than 900, but it is 2040. Then your lordship will see page 63, my lord. Your lordship got page 63. The complaints and the history.
Yes.
Mr. So-and-so, a known case of hypertension, DM dismemberment, presented with complaints of left-sided chest pain associated with shortness of breath with right, hypochondrial pain since 3-4 days associated with left knee pain. He is also a patient of osteoporosis, low backache. Initially, the patient was admitted in situ, evaluated and treated accordingly. On investigation, so-and-so, all parameters are wrong, my lord. Then your lordship will find even the blood pressure is 158 by HCM. Then your lordship will find at page 64, the course in hospital which was done. The first was CAG was done on 4/4/2025. CAG means that a coronary angiography was performed, my lord. So at the bottom, your lordship will find all these medications were given, my lord. 16 medicines. Then advisor discharge, my lord. Even your lordship will find ADB, CRTP, diabetic diet, blood sugar, continued physiotherapy, US massages, ultrasound therapy.
These are all,
Medical conditions suggesting that the man is sick.
but these are all reports of 1 year
Yes.
back.
Then your lordship call for the medical report of the doctor. That is before your lordship. Even hospital doctor. Even the hospital doctor who is not a specialist, he also by his report we can primarily found that his medical condition is not good even in the jail. That your lordship will find in the record. I think by your lordship's order, your lordship has called for the jail doctor's report. Even his medical condition is not good. Even if your lordship looks at page 69, there is always vital organ like kidney are all impaired, my lord. So I have annexed all the, my lord, what are the means to sum up the medical condition? Patient is a person who have gone chronic heart operation, diabetic, blood pressure, kidney impairment, spondylitis, arteries, and 73 years old. Can't even stand in the court in the dock, my lord. That is the present condition. So far the health condition is concerned. Second is, my lord, your lordship will see during this 10 months of custody, your lordship will see the first, what was the FIR? That but your lordship will look at the FIR at page 1722. 17 to 22 is the FIR. Or your lordship may look into the original at page 21 is the type copy of the SMS version.
Yes.
FIR was of 19/5/2025. So if your lordship looks into the FIR, your lordship will find that it looks like a case of aggravated penetrative sexual assault, like section 6, if you insert a finger or a foreign parts in your private parts of a small girl who is below 12 years of age. Now your lordship will see the evidence which were examined, PW 1, 2, 3, and 4. My case before your lordship today is that so far the family members and the victims are concerned, they have all been examined. So there is no question of going and influencing the witnesses because their deposition has already been recorded. But since the medical finding, because in the medical finding, we find that the doctor has gone beyond the findings which were beyond the observation in regard to the injuries which are there. So we have pointed out before the Honorable Court, therefore the Honorable Court has called that official witness, we will cross-examine that witness. So for the investigating officer is concerned, we'll cross-examination on the contradictions and all those things, that those are not, will affect the outcome of the witnesses who have already been examined. My lord, when we are on bail, my lord, when we are in custody, my lord, they even tried to cancel the bail before the trial court, and which they were, they said that we tried to influence the witness by giving money at that initial stage. But during the trial, when the deposition was recorded, there was nothing on record during the deposition. They have not made any such statement, or it was not proved any such statement. So that was at the very initial stage. Now, my lord, I respectfully pray that in a POCSO case, when we have to rebut the presumption under section 29 and 29 of the POCSO Act, and more particularly when the prosecution witnesses, they are all their starling witnesses or their star witnesses have all been examined. So there is no question of influencing those witnesses. Today, if I am not allowed to go on bail on health ground or my senior citizenship status, but at this stage, my custodial detention may not be necessary so far the trial of the case is concerned. Because at this stage, your lordship will not presume that I am guilty unless I rebut those presumptions. Because now, immediately after examination of the IO and the medical, because the medical finding, we pointed out that how these medical findings are not correlating with the observation made in the medical report. So therefore, the learned trial court has allowed the re-examination of the doctor. So I respectfully submit that my release at this stage will not hamper in the trial, except for keeping me in custody, my lord. Can't even stand properly in the court. And your lordship will see, even the jail doctor has given those medicines, which are of hypertension, blood sugar and all. But there is no medication in regard to heart and all. And there is no, it has become more a trouble to keep this man inside jail. So my respectful submission is that on any terms and conditions, and I have not even submitted my further credentials that I was an ex-army man who has given my best of my years to jail. It is unfortunate that this, I would not, because this will bring during the defense witnesses, that this mother of the victim girl took money from him, and when we to ask for return of the money, she has lost this false FIR against her. Even in the when we are cross-examining the mother said that the offense occurred about 1 month back. I did not come to to their place for about 1 month back. Medical report says that the injury is only of 2-3 days old, and the mother is a owner of a small stationery shop. Father is a Uber driver, and all the time, my lord, in the cross and all, we have proved that the girl was always with the grandmother. She was never left alone. All these things we have brought, but today I am not asking my lord to observe anything on the merit of the evidence that has been recorded by the trial court, because that may either prejudice my case or prejudice the case of the plaintiff. My consideration for bail at this is number one, the person is seriously ill. There is no doubt. 24 to 25 documents, and these are the which are with every day. If a person have a high blood pressure, diabetes, and he has gone undergoing a heart surgery, spondylitis, osteoarthritis, can't even stand properly, this condition will deteriorate further in the jail. And secondly, since the prosecution witnesses who are the victim, the mother, father, the mother, the auntie, who is a police officer, has also been examined. So at this time, if I am released, I cannot influence those witnesses. Those official witness who is on the 30th, this time also we wanted to examine them, but because of the election duty, the IO could not come, or the doctor also did not turn up, my lord.
Yes.
That's my respectful submission, that my custodial detention, your lordship may kindly consider that it may not require for the trial of the case.
Yes, Mr. Chairman.
Lordship, here already the petitioner has pointed out the dates of charge sheet and everything, Lordship. Lordship will kindly examine the statement of the doctor who was examining this PW1. I have flag marked, Lordship. There, Lordship will find that injuries are present in the private parts of the victim child, who happens to be around 5 years of age.
My lord, so far the short reply to his medical report. These injuries, it was said that I can point out, it was a tear in the hymen. It was not due to attributed to me, and it was very inconclusive and contradiction to what the other observation in the.
Heard Mr. A.J. Seka in appeal. Also heard A.J. Seka, Mr. Learned Counsel for the appellant. Also heard Ms. P. Borwa, Learned Counsel for respondent number
One, Lordship.
1.
Not.
1 and 2.
One.
Respondent 1 and 2.
One, only one, Lordship.
1 and 2 have filed wakalatnama.
Two is the driver owner.
In respect of 3 and 4, Lordship,
I'm appearing for respondent number 1.
in respect of 3 and 4.
Respondent number 1.
This report is awaited, Lordship, in respect of 3 and 4.
It appears that notice issued to respondent number 5 has been duly served, whereas notice issued to respondent number 3 and 4 have not yet returned. The registry is directed to place the postal track consignment report in respect of the notices issued to respondent number 3 and 4 by speed post before this court on the next date fixed. Let the matter be listed on 29th of April.
Like,
Item number 57.
I'm for the applicant claimant. I have to consider for withdrawal of the 50% amount.
Any objection?
My ground was, Lordship, that the rider was a minor. That was my ground, Lordship. It's a law point involved.
Oh,
But then
somebody died.
Yes.
Who?
My mother died.
Yeah, allowed, Lordship.
Heard Mr. S. R. Gogoi, Learned Counsel for the applicant. Also heard Mr. R. Goswami, Learned Counsel for the respondent insurance company. This interlocutory application has been filed by the applicant / claimants. How many claimants are there?
Only one.
Applicant / claimant. Praying for allowing the applicant / claimant to withdraw the 50% of the awarded amount which was deposited by the insurance company in person to the order dated 9/2/2026 passed in IA civil number 283/2026 in connection with MAC appeal number 37/2026. You are not objecting. The Learned Counsel for the insurance company No, I have considered the submissions made by learned counsel for both sides. Considering the fact that the connected appeal is pending at what stage?
Lordship, it is admitted, stay has been granted, I have deposited. Service on respondent 2 and 3 are yet to be completed, they are the main.
Is pending at the stage of completion of service of notice on the respondents. This court deems it proper to allow this interlocutory application. Accordingly, the applicants / claimant is allowed to withdraw the 50% or withdraw the amount. It is 50%.
Yes, 50%. So the amount is 3,02,500. It is deposited on 22/26. Paragraph 3.
Allow the 50% of the awarded amount, which was deposited, 50% of the awarded amount within bracket rupees 3,02,500, which was deposited by the appellant before the registry of this court on which date?
22/26.
On 22/2026 in pursuant to the order dated 9/2/2026 passed in IE civil number 283/2026 on furnishing furnish a bond.
Yes.
On furnishing a bond of rupees 3,02,500. The registry shall bond of rupees so and so, after proper verification. This interlocutory application is accordingly disposed of.
Service may be awaited because I will check the postal track after,
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. S. R. Gogoi, learned counsel for the respondent number 1, claimant. It appears from the office note that the service report in respect of other respondents are awaited. The registry is directed to place the postal track consignment report of the notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed on 15th of May.
Obliged.
Item number 28.
May I please your lordship, I am number 1096/2026. I am for the applicant. I am praying for allowing the applicant to withdraw the 50% of the awarded amount in terms of order dated 27.
Objection.
No objection, lordship. But lordship, subject to depositing indemnity bond.
Okay. Heard Miss, what is the name?
C. Bora.
C. Bora, learned counsel for the applicant. Also heard Mr. A. Kakoti, learned counsel for the respondent insurance company. This interlocutory application has been filed by the applicant claimants. How many claimants are there?
Only one claim.
Azifa Khatun.
Applicant / claimant praying for allowing the claimant to withdraw the 50% of the awarded amount which was deposited by the insurance company in pursuant to the order dated 27/2/2026 passed in IA civil number 632/2026. Stop. Since The learned counsel for the insurance company / opposite party has not objected to the prayer of the claimant, this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount within bracket rupees 31,08,000 only, which was deposited by the insurance company before it in terms of the aforementioned order of this court after proper verification, subject to furnishing an indemnity bond of rupees 31,08,000 by the claimant. This interlocutory application is accordingly disposed of. MAC case.
Lordship, as per the office note dated 6/4/2026, Lordship, for the respondent number 2, that service report is returned that he was not found that address, Lordship. And as for the respondent number 3, Lordship, there is no any report is come.
Oh, as regards to what will you do?
So Lordship, first step may be taken.
First step in the same address.
But as per the report, no address, no person is found in this
Okay,
place.
fresh steps. Heard Mr. A. Kakoti, learned counsel for the appellant. Also heard Ms. C. Bora, learned counsel for respondent number 1. Office note dated 6/4/2026 shows that the notice issued to respondent number 2 has returned with postal remarks within bracket no such person returned to sender. Whereas no service report has been received in respect of respondent number 3. Learned counsel for the appellant prays for allowing the appellant to take fresh steps for issuance of notice upon respondent number 2 and 3. The prayer is allowed. The appellant shall do so by speed post as well as by usual mode within 7 days of date of this order, returnable on 8th of June.
Item number 9.
This is a delay conjunction petition of 545 days. That's it. The matter has come for the first time.
Heard Mr. A.J. Sakya, learned counsel for the applicant. This application has been filed by the applicant insurance company for condoning the delay of 545 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of June.
Item number 30.
This is an application for condonation of delay of 27 days in filing.
Ms. B. Sharma, learned counsel for the applicant. This application has been filed by the applicant praying for condonation of delay of 27 days in preferring the connected MAC appeal. Let the notice be issued to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of June.
Item 31.
This is also an application for condonation of delay of 683 days in filing.
In same order, Only delay is of 683 day. Baki eke order thakibo, date eke thakibo.
Item 32.
Same, my lord, 9 days in filing it.
Same order, 9 days, delay 9 days.
Item 33.
This is a lordship listed for the first time. And there is a delay of 419 days.
Same order, council's name R.D. Majumdar, delay is of
419.
419 days, 15/5.
Item 34.
None appears for the applicant on call. List this matter immediately after due vacation on a date to be fixed by registry.
Item 35.
35 year lordship, the delay is of 204 days.
Same order. Council R.D. Majumdar, delays of 204 days. Next date is on 22/5.
Item 36.
Their lordship, the delay is of 127 days.
27 days, same order, earlier order.
Okay.
22/5.
Item 37.
Same, my lord, 117 days in filing it.
Council's name B. Sharma. Same order. Delays of
117 days.
117 days on 22/5. Next date 22/5.
Item 38.
Yeah.
There was delay of 129 days before the appeal.
Heard Mr. R.K. Moore, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been preferred by the applicants, praying for condonation of delay of 124 days.
129.
120?
9.
129 days in preferring the connected regular first appeal, connected first appeal against order. Issue notice to the respondent. How many respondents are there?
Single one.
Notice to the respondent. The applicant shall take steps for issuance of notice upon the respondents by speed post, as well as by usual mode within 7 days from the date of this order, returnable on
8 June.
8th of June.
Item 39.
Lordship, delay for continuation of delay for 185 days.
185. What is your name?
S. Das.
Heard Mrs. Das. Same order. Delay of 185 days. Next date is
8th of June.
no 22 May. 22nd May.
Item 40.
Condonation of delay of 72 days.
Council name B. Sharma. 72 days delay. Next day is 22/5.
Item supplementary item 42.
My lord is in withdrawal application for the money deposited, my lord. Here the applicant is in widow mother of 57 years old, my lord. The accident had
It
occurred.
is not a withdrawal application.
My lord, the withdrawal for the money. which
But
is
withdrawal of
my
money.
lord,
Otherwise, it appears that you are going to withdraw the,
I cannot withdraw the appeal of insurance company. my
because
lord.
it is not your.
No, my lord.
You cannot touch my.
My lord.
Okay,
So, my lord, I am ready to submit an indemnity bond, my lord.
I have
yes,
objection.
yes. What is your ground?
First objection, Lordship, the petition which is filed in that the owner and driver are not made party. We indemnify the owner and without them and moreover, our appeal is based on violation of policy condition. They are necessary party.
My lord,
Our High Court own judgment. If you want to
No, no,
finish,
no.
you finish,
Finish.
otherwise don't disturb me. Our High Court own judgment that day in other case also I showed Lordship that the owner is necessary and without the owner being present, the amount was not allowed to be released by the, even by the tribunal in the IA itself, Lordship. I had submitted this Sonali Kolita judgment earlier, interlocutory in another case, Lordship. I still have that case. So the
Can I get
owner, yeah, IA 3149 of 2017 by Justice Surana. So Lordship, the petition is not mandatory.
What was held in that case? Whether any law has been laid down?
This is in the final year also, it was, yes, law was, it was, Chala Bharatamma judgment was followed, apex court.
Your submission is that unless you make owner and driver parties in the interlocutory application for withdrawal, same should not be entertained. That is your submission.
That is my submission, because Lordship, it is settled law that insurance company indemnifies the owner. Owner is liable because the driver is liable, vicarious liability, because the driver has caused some injury to someone, so owner is liable. And because owner is liable, insurance company is liable. Otherwise, we are not directly, we have not caused the accident. We are coming through that. If they are not made party, Lordship, how we are liable to pay? They have to make the, and that's why I thought when the withdrawal came in the morning, Lordship, I thought he was withdrawing to, in fact, include the owner and driver. That's what I thought, that withdrawal petition was because of that.
Let's complete, my lord. I will.
So basically, maintainability, Lordship.
If that
Else-
is, my lord, my submission is simple, my lord. Here, what has happened is this, that the owner and driver is the one person only. The services, the issue number 4 in the judgment, the court has looked into this issue. What is the crux of the matter was that the owner apparently has not submitted the driving license. The court has clearly said that even though the owner has not submitted the driving license, the liability on the insurance company is cannot be shifted. That, my lord, will find in the page number 7 of the judgment, my lord. I do not have the appeal copy. Appeal copy has not been given to me. If my lord will allow, I will read that part of the order which has been submitted with regard to the owner and driver. Then my lord will decide whether owner and driver in this application is necessary party or not. It is not a case of pay and recovery, my lord. It is a case where the liability has been shifted entirely on the insurance company. Let me read that part, my lord. Para number 10 of the, my lord, judgment. And that judgment, my lord, will find the internal page number 7 of the judgment, my lord. So claim petition states that at the time of accident, the offending motorcycle was insured with OP number 2 by policy number such and such. And the record is replete with the material. Vide form 54.
No, otherwise also.
My lord, I'll see why it is not
with the-
necessary. If the liability is shifted entirely on the insurance company, the owner and driver is not required to be made party in an application which has been filed to get 50%. If tomorrow my appeal is, if their appeal is allowed, my lord, then my indemnity bond is there. I'm not shying away. The
lady is poor, she is old, from where
Let
she
me-
will be giving back the money,
Let
Lordship.
me-
That
let me
is
complete.
very,
Let me complete, my lord, or at least I will be given that benefit of my lord. Now, my lord.
No, the lady is old and she is poor.
Hmm.
That is a good ground for.
No,
Granting the relief, my lord.
indemnity bond, Lordship, how they will
No,
return
but
that?
that is a good ground for not depriving her from the.
No,
Yes,
that
my
is
lord.
their submission. I am looking at their submission, Lordship.
I'll make my
What is
submission.
he is submitting, Lordship. How, from where they are saying about indemnity bond, from where they will be returning. But Lordship, here the basic maintainability of the petition I am questioning here. Instead of going into whatever he is reading the judgment, para 10 and all that, Lordship, whether the petition itself is maintainable.
That is what, my
what
lord, I'm submitting, my lord. If I should be allowed to complete, my lord.
let me address the first point first, because that is what has been said. From where I will be refunding the money. My lord, that has been answered in the notification of 43. That notification has laid down, High Court has laid down an SOP. The majesty of this honorable court cannot be taken lightly. That this, because somebody is poor.
Objection then, Lordship. I'll
My
put
lord-
a formal objection to
lord-
this petition.
That majesty of this honorable court, my lord, cannot be taken away.
As this is going to be a contested matter,
Yes, Lord.
let her file written objection.
Yes.
My lord, in this case, service is also not been complete, my lord. Please appreciate, my lord, 2019, somebody has.
No, we'll decide your interlocutory application at the earliest.
My lord, please-
Without tagging, keeping it to be decided along with the
Because
application.
the owner is evading service. That's the, yeah,
The
Lordship.
address
that's
was
what
insufficient. That is what has been written in the office note, my lord.
address was given by them. The
did
claimant,
not
whatever claimant gave the address in the claim petition was mentioned in the year. And Lordship, usual process notice has not yet been. So registry may call for the usual process report, Lordship.
No, otherwise, they are beneficiary of a award of the tribunal after contest. Unless you have a very strong ground,
Yes, Lordship.
they should not be
First
deprived.
of all, maintainability,
during the
because
pending.
without the owner come driver, how can we be made, when we are questioning the judgment, he's reading the judgment, that judgment we have challenged, Lordship. That is the judgment which is under challenge.
No, mere challenge to putting judgment under challenge will not deprive a decree holder.
Decree holder.
He is just like a decree holder. Merely because you have challenged something.
But in absence of the person whom we indemnify, what I'm.
You have deposited 50%.
Yes, what we are, yes, we have deposited. What we are questioning is that whether the
In
petition.
in the event of allowing of the appeal, they may not be in a position to indemnify.
Yes.
Okay, let her file objection. You also see whether this defect of non-impletement of other parties.
My lord, yesterday only my lord has passed in similar order, my lord, in the same case, my lord will remember. where-
No, that
My
was
lord,
different.
I'll complete, my lord. In the yesterday also, my lord has seen this order.
No,
I'm here, no issue.
That is, if brushing away objections isn't, my lord, I'll not submit anything. But my lord is asking me a question. My lord, I'm trying to answer that question. Yesterday also, my lord has.
No, both of you argue every day. Various matters, many matters. So you should not get upset so quickly. There should be some level of tolerance. Let her file.
My lord, please, I have not
written
objected.
objection.
Let her. My lord, the IN number can be given to me, my lord, which my learned senior is there.
I've given you.
Third, Mr. A.B. learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for the opposite party insurance company. This interlocutory application has been filed by the applicant claimant claimant praying for allowing the applicant claimant to withdraw the 50% of the awarded amount which was deposited by the insurance company in pursuant to the order dated
11/6/2025.
11/6/2025 passed in I number
IN number, my lord, is
1866 of 2020.
1866 of 2025.
Five.
Stop. Learned counsel for the insurance company vehemently oppose the prayer made by the prayer of the claimant applicant and prays that the insurance company may be allowed to file a written objection against the instant interlocutory application. The prayer is allowed. Let this matter be listed again on when? 29.
any date comfortable to my senior.
Lordship, let it be in May, Lordship, because already many cases.
Suggested it.
maybe May 12th, Lordship, it is a Tuesday.
12th of May. Before that day, the insurance company may file its written objection with an advance copy by furnishing an advance copy of the same to the learned counsel for the
Without giving, we cannot file. They won't allow, registry won't allow us to file.
learned counsel for the applicant list accordingly. Appeal some.
In the appeal, Lordship,
appeal.
only two respondents are there. One has filed wakalatnama for two unserved notice, insufficient address. But this is the same address which was mentioned in the claim petition, Lordship. But the usual process report has not come. So registry may call that at least. Because that must have gone.
Where is the
Office.
Office note 7.
no address?
Address, Lordship.
What is the address of the?
Address is Kachar, Silchar. Because basically case is from there, Lordship. District Kachar. This is the same address mentioned in the claim petition, Lordship.
In claim case, whether the owner appeared,
Yes, my lord.
Yes,
Filed
he
a
appears.
he contested.
Not contested, but he filed his written statement. Court has mentioned after that he did not appear. In the judgment, it is
Para
mentioned.
number 4 of the judgment, my lord, has been recorded.
In the written statement, he has given his address. No.
My lord, I have to, I do not have his,
Where-
my lord.
We do not
We-
get copy of written.
We await. No, before the tribunal also you do not get.
No, the
You
opposing
are-
party do
oh,
not. It will, they will get, but
My
we
lord,
do not get.
The WS, my lord?
No, as the report is that address is not sufficient.
My lord.
You may find out whether is there any other complaint.
I will try to speak with my
He is an individual
instructions, my lord.
person, Lord. He was the owner driver and that was the address in the claim petition and there he appeared in that address itself. Now I know he is avoiding that I can feel. Because
At least
of
office
our-
note, my lord, is silent on this part. LCR is either, I think, my lord is.
Last time. Into ayat likhi se. Main appeal heard Miss Hadi Majumdar, learned counsel for the appellant. Also heard Mr. A.B. Day, learned counsel for respondent number 1.
I may be provided a copy of appeal memo, my lord.
Yes. The office note dated 7/4/2026 shows that the notice issued to respondent number 2 has returned back with a postal remark within bracket insufficient address returned to sender. However, the service report of the notice sent to the respondent number 2 by usual process has not returned. Registry to issue a reminder to the concerned court or calling for the report of process server of in respect of the notice issued to respondent number 2 by usual mode. Stop. How many?
two.
It.
And Lordship, to them, we have already given them copy. That's how he entered appearance. Because
Lord, we
notice
have
was
filed-
signed.
We had filed an actually execution case, my lord, in this case. And that is how my client got to know that there is an appeal. I have checked with my client. They have not
Notice
received.
was sent that.
That was when I was being instructed by my client. I have checked in the morning itself, my lord. They have not received.
You furnish a copy.
Lordship, that we should send simple notices and not the copies, and when they appear before
Registry will not send it.
that's what Lordship, they got it. They got the copy.
Still
and
not
now,
giving me, madam. Correct, madam.
not- because I have sent, I will believe myself that I have sent. I know that.
We are not disputing.
Yes,
You might have sent it, but still he may not get it
because his
for,
client is not sending him.
for other reasons.
No, that is his client is not
That may
sending
be
him.
one reason.
Yes, that is
All
one
prejudice is
reason.
against my client, my lord. only.
Only one reason.
My client is poor, so he should not be getting the money, my lord.
The
I'm not saying
learned counsel for the appellant is requested to furnish a copy of memo of appeal along with annexures to the learned counsel for respondent number 1 within a week from the date of this order.
working days, Lordship, because holidays from tomorrow.
7 working days from the date of this order. List this matter again on IATT date
12 parts.
on 12th
12th, my
of,
lord.
12th of May.
Item number 46.
Lordship, as per office note dated 7/4/26, AD and SR of 3 and 7 are awaited, and LCR is also not received.
Heard Mr. A.J. Learned counsel for the appellant. On perusal of the office note dated 7/4/2026, it appears that service report in respect of notices sent to respondent number 3 and 7 are awaited. The records of the concerned MAC case has also not been received. Registry to issue reminder for the records of the MAC case number. How much? What is the MAC case? Records of the MAC case number 63/2014 from the concerned tribunal. Registry shall also place the postal track consignment report of notices sent to respondent number 3 and 7 by speed post before this court on the next date fixed. List accordingly on 15th of May.
Item 47.
Please, Lordship. Respondent number 2 has appeared, Lordship. Respondent 2. And respondent regarding respondent number 1, Lordship, office note says step is not taken. But how it is taken, Lordship, I will take first step.
Heard Mr. P.J. Burman, learned counsel for the appellant. Also heard Ms. P.B. Bordole, learned counsel for respondent number 2. Learned counsel for the appellant submits that he may be allowed to take fresh steps in this against respondent number 1. The prayer is allowed. The appellant shall take fresh steps for issuance of notice to respondent number 1 by speed post within 7 days, by speed post as well as by usual mode within 7 days from the date of this order. Returnable,
LCR I think is not received.
returnable on 15th of May. The
After 15.
29th of May. The registry shall issue a reminder for requisition of the records of the trial court. List accordingly.
Obliged, Lordship.
Highly obliged.
Item 49.
Please, Your Lordship. Before that, Lordship, in item 42, Lordship, the LCR has not come. So reminder for LCR.
Item 42, the item 42 legible. The registry shall issue reminder received. 42
Dada South Sikun. Office note तो देखा नहीं एक अच्छा
42 record to so.
होई गोल
Let them file.
Yes, Lordship 49, Lordship, Office Note 7464, that notices have just been sent, so we have to.
Miss R.D. Majumdar, learned counsel for the appellant. On perusal of the office note dated 7/4/2026, it appears that though notices have been issued, service report is awaited. The registry is directed to place postal track consignment report of the notices issued to all the respondents by before this court on the next date fixed. Let this matter be listed on 29th of May. In 42, LCR is there.
LCR is there. Lordship 50, 51, 52, all are not analogous cases, but the report is same, Lordship, and of the same date, Office Note.
These are not analogous.
Not analogous, but the Office Note are same, so same order will be.
50 some. Heard Miss R.D. Majumdar, learned counsel for the appellant. And the office note dated 7/4/2026 shows that notice has been issued to respondent number 325 by speed post. However, service report is awaited. The registry is directed to place postal track consignment report of notice issued to respondent number 325 by speed post before this court on the next date fix. Let this case be listed again on 4th of June. 51.
51, Lordship, for respondent 1, 2, 3. And LCR awaited.
Same order in place of respondent 325, write respondent number 1, 2, 3. And date is same. 52.
52, Lordship, 1, 2, 3. Notices sent by speed post.
Same order. Respondent number 1, 2, 3 by speed post. Same order. Date is 5th of June. 4th of June.
Happy Bihu, happy holidays, Lordship.
Same to you.
Thank you,
also.
and to everyone.